Good morning.
Good morning, sir.
Good morning, everyone. We are starting with the second day's proceedings of this workshop. And the first session is devoted to couple therapy, communication skills, techniques for effective resolution of family disputes. We have with us this morning Honorable Justice Meenakshi Mehta. Justice Mehta brings rich experience, a service area judge, started in the year 1987, 31 years at the district level. What rich experience. Various postings and varied experience she combines. And in the year 2019, she was elevated as a judge of Punjab and Haryana High Court. A blend of such long experience. I normally say that judicial education means senior judges share their experiences with the younger judges. And that is what we are looking forward from Justice Mehta in our concluding remarks for this particular session. The resource person of this session is Madam Arzu Gupta, Assistant Professor, Clinical Psychology, Department of Psychiatry, Government Medical College and Hospital, Sector 32, Chandigarh. She would be making the presentation on this particular topic, and towards the end, we would have the concluding remarks from Justice Mehta. We are keenly looking forward to her contribution and her presentation, Arzu Gupta's presentation in this morning's session. Over to Arzu Gupta.
Good morning, everyone. And thank you, sir, for your kind words. Thank you. So, first of all, I congratulate Chandigarh Judicial Academy to conduct this workshop, and I thank the organizers to give me this opportunity to be part of this program. So, I will be talking about couple therapy, communication skills, and techniques for effective resolution and family dispute. So I being a clinical psychology professional, so we usually look into, we have a marital sexual clinic in Department of Psychiatry, GMCH, and I have been in the department since my recruitment in the hospital since 2012. So how we work through with the couples, and that is the journey I will be sharing. So first, let's understand what is a couple. Couple is a person who's married spouse or common law partner in the family, regardless of having children or not having children. So it also includes couple could be a married couple, could be live-in partners residing as couples, or even other couples in any other form. So couple is different from dyad. Now, when we talk about couple, it can be it is spouses. But when we talk about dyad, it son, daughter, son, daughter-in-law. So dyads is any two person, the pair of two persons where we try to assess the interpersonal communication. So when we see a family, we see couples, and we also identify a lot of dyads in a family. So to begin with, let's understand couple therapy is synonymous with family therapy. So the principles and the techniques that we follow in couple therapy are the same for family therapy. These are synonymously used terms. Couple or family is a system which passes through time. There are many subunits which are organized and independent in their own way. So there could be various subunits when I say mother, daughter, son, siblings. So there could be different units which impact, or the interaction of all these subsystems together determines the functioning of a couple or a family overall. So there are a lot of emotional systems, and at least 3 generations are included when we talk about couple or family therapy. Why 3 generations? Because when we see a couple having marital dispute, or a family as marital dispute, it's not only between two individuals. It is usually, sometimes they are attributing these problems to the previous generation, parents or in-laws. And a lot of times the problems between the couple are attributed to the next generation, which means their children or children's spouses or children's academic issues or relationship issues or sexuality, etc. So now what do we do as a clinician? First, we need to understand is we identify the problem. Now, how do we identify the problem? So when a couple approaches or when a family approaches for the issue, so we try to listen to the perspective. What does the husband say? What does wife say? And if children are adult, and if we think we can include children in interviewing, then we listen children's perspective of mother and father and their issues. And also, if needed, other extended or joint family members are included in clinical interview. So once we have gathered this information, then we gather the history of relationship. Now, suppose a couple comes to me in 2020 and they have been, married since 2015, or they have been married since 1995. So I understand all these 5 or 25 years of their relationship, how the relationship went through different ups and downs. We try to understand the family structure, joint family, nuclear family, extended family, who lives where, whether the couple is living under the same roof or both spouses are working, and there is a distant relationship or a distant marriage that they have been putting up with. The functioning, how does the function, who takes the decisions, who takes what kind of decisions, financial decisions, and related to other decisions in the family, decisions related to education, decisions related to academics, decisions related to day-to-day household chores. So how is the family functioning? Which member of the family contributes to what kind of role, and where does he stand in the structure, which means hierarchical position in the family? Then we understand the relational patterns. Relational pattern is, suppose the family has 5 members. So what is the relationship of 1 and 2, 1 and 3, 1 and 4, 1 and 5? Similarly, relationship of 2 with 3, 4, 5 respectively. Suppose there is a family of husband, wife and 3 kids. So we understand between the husband, wife, husband with child A, husband with child 2, husband with child 3. Similarly, wife with child A, child 2, child 3. So this helps us to understand the relational patterns, because we see sometimes one child says that I'm more close to mother, another child says I'm more close to father. And also other family members, if they have significant roles, like how is the female getting along with the in-laws, how is the female getting along with her own siblings, her own parents. Similarly, the male, How is he getting along with his siblings and his family and the in-laws family? If we have to require, if we require to look into that as well. Then major events and transitions, because as we all know, any family goes through lots of ups and downs. So if a couple comes to the clinic or for professional help, then obviously, or for that matter, even if a couple approaches you for, separation or dispute. So this doesn't happen in a day. There must have been a sequence of events and they must have, traveled this journey together, resolving a lot of conflicts. So we try to understand what were the major transitions in the life of a couple or a family and how did they react to it? How did they manage all of that? That helps us to understand how they have been addressing and dealing with their problems or how they have been seeking solutions and making decisions in the past. So why now? If you've been married for 10 years, 15 years, 20 years, you've always been unhappy or you have always been happy. So what triggered now that you reached the clinic? Or for that matter, what triggered now that the couple approached the legal system for help? So we try to understand what triggered this. So maybe there was a, suppression which had been there for years and it just bursted now. So what led to it? Or maybe there's an extramarital involvement which had been there in the past, or maybe it was never there, but recently something happened that, one spouse got involved out of marriage, or maybe there is a child born, or maybe the child has failed, or maybe the child has disclosed his sexuality, or, which we see now, which earlier in at least when I was a student, I've never seen those cases. But sometimes, if the child is an LGBT or lesbian or gay, so he discloses and then how the family splits. Whereas earlier we used to usually see couples where, one child is born with certain disability and the family splits and then suddenly, there are teams built within the family. So we need to understand why now, what triggered to the current conflict or situation where they decided to seek help. Now, in this assessment, so far, all these points when we gather, so this helps us to understand where is the family right now in the family life cycle. There is a courtship period, marriage and consequences, childbirth and rearing in the family, middle of the marriage when children are, growing, and the crucial years of crucial decisions about children, especially their career and marriage choices. Then weaning of children, retirement and old age. So we try to identify where is the couple or family in out of these stages, because each stage has its own kinds of conflicts. Each stage has its unique problems, and the way we intervene is also will vary depending on the family life cycle stage. So normally we try to identify, now this is the background, now this helps us to conclude whether there are compatibility, intrapersonal issues which are contributing intellectual compatibility. So when I say intellectual compatibility, sometimes in the clinical situation we see that one spouse has an average IQ or a superior IQ, but the other spouse has intellectual disability. Now, the intellectual disability was not disclosed at the time of marriage. So, but 3 months or 6 months of marriage and the disabled spouse or spouse with disability has not been able to take the family roles and responsibilities. So then consequently, marriage leads to a dispute. Now, intellectual compatibility can not only be an issue when one spouse has intellectual disability, but also suppose one person has intellectually very high interests and very varied interests, whereas the other person intellectually is very average, but maybe 90-92 IQ, but another spouse is of 115 or 120 IQ. Now, beauty is when there is a man with higher intelligence, the marriage succeeds. But in certain couples, when woman has a higher intelligence and man has a 92 IQ, then there are more conflicts. So we try to understand the intellectual compatibility. Next is personality compatibility. We all, very commonly talk about unka nature alag hai, unka nature same hai. So when we talk about personality compatibility, we don't only try to understand the personality traits. One person is an introvert, another is an extrovert. So what happens now? Introvert person wants the weekends to be spent at home. Extrovert person wants, friends and family to be invited or visiting people on the weekends. So these things can also sometimes create a conflict between the couple. Now, beyond personality traits, we also sometimes find there is a personality disorder in one spouse, or two spouses are on different extremes of personality type. I'm not using the word trait. So there is a trait, there is a type, and then there is a disorder. It's on a continuum. So personality trait, personality type, and if there is a personality disorder. Now, if one spouse has a personality disorder, it could be, I'm sure, the clients coming to you, people use this term, narcissistic partner, toxic partner, abusive partner. So usually when there is so much of toxicity or abuse, it is usually there is some underlying personality disorder, not the type or trait. Personality disorder, which is a clinical condition and which requires long-term intervention of 2 to 3 years of treatment. Now, the couple may be willing to invest that much, or maybe a spouse is not willing to invest that much to make the marriage work and decides to part the way and file for separation. So I, as a clinician, I will never give them a choice. My job is only to facilitate the process. If he says, yes, I want to make the marriage work, we start that journey. If he says, I want to, I don't want to continue, then I say that, okay, legal aspect is not my domain, but how they go through it, sometimes, people go through grief, people go through a lot of vacuum. So we work on those issues. So we try to understand the personality compatibility, where a formal assessment is carried out and identified spouse with the personality disorders is advised and may undergo long-term intervention. Psychopathology. Now, it's very well known to all of us that in Indian culture, even if one person has any illness or any kind of limitation, it is usually hidden. And, in especially arranged marriages, it's portrayed that, okay, the individual is very, it's like perfect picture is drawn and portrayed. So psychopathology sometimes may manifest and be disclosed after marriage. Psychopathology can be anything. It can be, maybe one person has history of depression, or patient has, an individual has a history of obsessive compulsive disorder, or the person has anxiety issues, or the person even has had schizophrenia or psychotic episodes or bipolar or manic episodes, but that was never disclosed to the other family or while the alliance or the marriage was being arranged. So now this psychopathology, after gradually, obviously, then, sometimes people stop taking medicine, ke bhi shaadi hui hai, to, 6 months, it's good not to take medicine. Now what happens? It's like a vicious cycle. When you don't take medicines, the symptoms start surfacing and values and goals. Values and goals, we all have, very unique values and goals. So sometimes we see couples where the husband has seen that, okay, my father used to cook for my mother. So even I have to cook for my wife. Sometimes the girls, they see, okay, every Sunday, Papa used to cook meal for all of us. So they expect that, okay, I expect my definition of a good husband is somebody who cooks meals on Sunday for the family. Now, if he could be doing 10 other good things, but because my idea of a good husband was my father cooked meal on Sunday, so my husband should cook meal on Sunday. That is what defines him a good husband. So they tend to sometimes discount all the 10 things because the basic idea has been conflicted of a good husband or of a definition of a good wife. So that's why when we see couples, we always try to understand the marital relationship of the parents of the spouse. So if a boy and girl, if a husband wife come, I try to understand the relationship that husband witnessed between his parents and the wife witnessed between his parents or even siblings, the couple siblings. Because all of us as humans, the first marriage that we witness is between our parents. So our idea about what marriage is, it definitely comes from our parents because that is what we witness all our lives. Or other significant other people living in joint family, chacha, chachi, taya, tai, somebody is, there is a huge gap, there's a generation gap, there is 5 years older siblings. So the sister got married and how sister and brother-in-law get along, or brother got married, brother and sister-in-law. So those are the marriages which people normally witness in our families. So we try to understand how are those marriages and what are the perceptions of marriage of the individual. So values and goals could also be, suppose a woman has plans to have a career, but that was never communicated to the couple. Or they said, "Acha, job karna hai, kar lena, koi baat nahi." But sometimes you don't realize that, okay, if somebody is doing the job, then there also comes a roles and responsibility you have to play with the job. Suppose there's a teacher, or suppose there is the teacher will have to prepare the lecture. Being teacher doesn't mean that you will just simply go to school, deliver the lecture and come back. Being teacher also means that as a person, I have to sit for 2-3 hours or 1 hour and prepare lecture. Even if somebody is taking tuition, so there will be children coming to your home from 4 to 6, and she will be diverting her time. Now 4 to 6, she cannot serve evening tea to the family or to the husband. So sometimes values and goals are not very well communicated, or maybe as a husband you think, हाँ working है तो अच्छा है, but you, Sana, the package that comes with a working wife, with a working spouse, that is something sometimes not interpreted. And when you start living under the same roof, that is when you realize that, okay, working means ke ye kaam aur itna time pe she will not be available. Or sometimes you expect that you will be doing both the roles, which sometimes women are not able to cope, then that also brings to the conflict. Similarly, it is the other way now. When women see that, okay, he has a traveling or touring job, I am okay with it. But when he starts touring 4 times in a week, then women start having problem that how do I deal with my loneliness or boredom? So this is something they thought it's a touring job. He's well placed and a very good alliance. They say yes, but they didn't understand that when the husband is on tour, maybe he's not able to take the wife along and she will have to live alone for so many days in a week, and she'll have to learn to cope up with that environment or be with the in-laws without the husband. So values and goals are sometimes not clarified to each other when a couple gets into marriage, and that also generates conflict. So this is intrapersonal, matlab factors within me, my intelligence, my personality, my psychopathology, my values and goal clashing with the intelligence, personality, psychopathology and value goals of my spouse. Now comes interpersonal, between two people, what plays? The interplay of physical environment. Physical environment can be simple thing like breakfast time, lunch time, dinner time. Financial sources of the family. So anything which is physical, the kind of 1-room accommodation, 2-room accommodation, 5-room accommodation, living in a rural or urban city. So anything which is physical, the physical environment can also cause issues. Emotional environment. What is the emotional makeup? Some of us, we react very strongly. Some of us are very low on reaction. Some people get more angry. Some people get less angry. Some people, when in pain, they don't express. They expect the other person to understand. Some people like to be left alone when they are in pain. So the emotional makeup of each individual also spills on marriage. Then social environment, the practices, the rules of the house, socio-cultural practices, rituals. And that's why when they say, that when you marry within your culture or religion, the marriages are, it's easier to adjust. It's nothing, but the idea is because that you're familiar. And when you are in unfamiliar waters, of course, you have to, test the waters. So it takes more time for you to know before you determine your reactions and responses. So we conclude and we have a mutual discussion around this. Now, how to address? By now, we have addressed the problem, we have identified, we know, okay, what is it that is bothering and what should be the goals. Now, how to address the problem? So what do we do? Ultimate goal is marital or family harmony, but how do we achieve it? 2 things which are very important is perspective taking. Perspective taking is I say, okay, this Sunday I want to go for an adventure sport. I just plan my trip, I don't inform my spouse. Obviously, my spouse is going to react. So when you live in family, when you live in a unit, it is not that you are free to do everything. There could be liberty to do things, but there is also something known as agreement and making arrangements. So if I'm going to be away for 2 days, I have to discuss and put things in place. How are the responsibilities and roles to be divided or assigned or outsourced or be ignored for 2-3 days? So that kind of a planning has to be done so that the functioning is not disrupted. So when I plan a trip, I must take the opinion of my spouse. It's not about taking permissions, but it is a mutual communication that 2 people decide that, okay, how are we going to work around 2 days if you're taking leave? And if he says, okay, why don't you go on next weekend? Because the next weekend I am free and I can be home so that the family functioning is not disrupted and you can be away. So this kind of discussion, always taking an opinion and perspective of the other person and emotional intelligence. Second most important theoretical concept in marital harmony is emotional intelligence. Now, emotional intelligence means I am aware of my emotion and I regulate my emotion. Suppose my friend says, okay, let's go here. And I suddenly get excited and I make a plan. So if I get excited, I have to think logically, can I really afford to go this weekend? So I hold on to my emotion and I understand, why do I want to go? Just because somebody else is saying, just because I'm excited, or I really genuinely need or want to go. So managing and identifying your emotional state, how you are making decisions. Then emotional intelligence is also about understanding the emotion of the spouse, of children, of other family members who are living under you, under the same roof with you. Now, if I say, like I said in the earlier, if I say, okay, I'm going for the weekend, obviously it may. That's what I planned. You know, these are the 10 things which need to be taken care. These 3 can be outsourced. This can be done this way. So having a discussion and planning that definitely makes the other person feel that you did not just randomly made a plan, but try to consider other people also participate in certain decisions. So we work around this when a couple comes. We teach perspective taking, because normally what happens in perspective taking is what I say and think is the ultimate thing. So sometimes couples stop participating, stop seeing the need of the spouse, the need of other family members. That is when the conflicts rise. Now, how do we both these combination? What do? They enhance the communication between a couple. They enhance negotiation skills between the couple, which automatically enhances their interpersonal relationship and finally leading to marital and family harmony. How we do this? So let's understand what is communication. Communication is basically, I want to tell you something, how I communicate that. Now there are interpersonal and intrapersonal processing skills. Now if these inter and intrapersonal processing skills are also part of all of this. Intrapersonal, the way I talk, it will depend on my intelligence. The way I present my point will also be affected by my personality, psychopathology, and the way I have been taught how to my values and goals. And also other factors, like, you know, especially when we see couple living in a joint family or even in a nuclear family having children. So the physical environment, emotional environment, suppose a child falls sick, that okay, mama or papa cannot go. So now what happens? The dynamics between the couple will change. So the husband or the wife is okay if the spouse is going, but the child has fallen sick or the child is not willing to let the parent go. Social environment means other social responsibilities. There's a family wedding or there is something else, you know, one of the spouse has to go for a conference out of station. Now there is a family function. So how do you, sometimes the couple is totally fine with it, but the social obligations and people feel that, okay, why couldn't you, stop her? The marriage would have been more important. Why did you let him go? So different people or different social rituals can also sometimes induce different situations and can be part of communication, which sometimes is not realized. So basically, communication is a social process through collaboration and cooperation in all domains. Now let's understand the communication loop. There is a sender. I want to say something to the audience. Like right now, I am saying something, communicating to the receiver, which is audience. So my characteristics and resources, my professional resources, my intellectual resources, my access to internet, my access to laptop, my access to headphones, all of this, the resources could be human resources. The resources could be also physical, economical, or other resources. My characteristics will impact. Some of us are very average presenters, some are above average presenters, some are low average. So your knowledge base, your skills, everything contributes to the sender. Message. What is the message? Whatever the content and the topics that I'm delivering. Medium. Now, what could be the medium? Medium could be face to face. We all sitting in a hall and, I'm talking to you. We could have interaction. Or It could also be online, like how we are having now. It could be through a video conference, it could be through email, telephone, whatever, Zoom, Go Meeting, Google Meet, etc. So what is the platform that you choose? Now, medium is usually puts our communication into either verbal or non-verbal. Verbal is whatever words I'm saying, and non-verbal is my gesture, my facial expressions, movement of my hands, my body, etc. So receiver, now whatever I say, the interpretation, that's why they say na, interpretation is in your head. We all see what we have in our head. So whatever I speak, the interpretation will also rely on your resources and your characteristics. Suppose in a family, mother criticizes both children equally, but one child is okay with the criticism when mother says कि TV बंद करो पढ़ने का time हो गया. But the other child says कि आप हमेशा control करते हो. क्यों? Because that's his interpretation in his own head, the assumptions that he's carrying, the past experiences that he's carrying, the image that he has made, कि okay, I should not be criticized. So person's own characteristics and resources also determine how you interpret the message. And then there is always a feedback loop. When I say कि TV बंद करो, एक बच्चा उठ के अपना पढ़ाई करने चला जाता है, दूसरा बच्चा मुझे बोलता है you always control, and then I explain to the child, no beta, it's not about controlling. You have exams in the next week, and it's not that I'm only telling you, I'm telling both of you. So this is very important, explaining that why I am saying what I'm saying. Especially when it comes to human relations, that helps us to hold on to our relationship safely. Because this minimizes the communication gap. A very quick demonstration I can give here. Suppose if I say, suppose there's a person, we don't have, otherwise we could have used that. मुझे ये पकड़ाना. अब सामने वाला पूछता है क्या? यार ये पकड़ाना जो इधर पड़ा है. और I clearly say मुझे मेरा प्लीज वहां से ना ये 2 फोन है, रेड वाला फोन पकड़ा दो. Now, there was a communication gap in my first sentence when I say मुझे ये पकड़ाना. I leave it to the other person to assume and interpret के मैं क्या मांग रही हूँ. There's a lot of communication gap. When I say मुझे ये रेड 2 फोन पड़े ना, वो रेड वाला राइट साइड वाला मेरा पकड़ाना. Now I'm very clear with my communication. So the way I frame the sentence also determines the communication gap. और जितना communication gap ज़्यादा होगा, रिश्ते उतने खराब होते हैं. Similarly, sometimes I can fill the communication gap. Sometimes even the receiver can fill the communication gap. Suppose I say मुझे ये पकड़ाना. सामने वाला कहेगा अच्छा फोन के बॉटल, पानी की बॉटल. There, I said मुझे ये पकड़ाना, पर सुनने वाले ने कहा क्या? फोन के बॉटल. So the receiver filled the communication gap, and there was a lot of communication gap in my sentence. So we try to understand the communication pattern of the couple or of the family within the sessions, and we try to understand कि कितना communication जब आप clearly नहीं बोल रहे हो और सामने वाला कह रहे हैं कि always this one is doing that, always this is happening. So we try to observe the communication through all this. Sender, message क्या देते हो, medium क्या देते हो. Like I remember there was this couple. So what they did कि जी मैं तो घर पे शाम को जल्दी आने लग गया. मैंने तो बोला नहीं था. The wife said कि मैं तो शाम को वॉक पे जाती थी, अब अगर ये जल्दी आ जाते मेरी वॉक कैंसिल हो गई. The husband changed his routine to be with the wife. अब यहाँ communication gap क्या है? At least tell the wife कि I'm planning that we should spend time and have tea together. So that is the communication gap where they both could have decided कि नहीं मेरी वॉक है जो 5 to 6 होती है तो ठीक है मैं 4:30 to 5:30 वॉक कर लूंगी and 5:30 से 6 हम चाय पी लेंगे. So this kind of communication gap, which is very common in any interpersonal relationship, it's not only between husband wife. That's why I use the word diodes. It can be between any 2 persons in the family, which will have a spilling on the entire family unit or on the couple. So we identify the channels, how they say, what they say, verbal, non-verbal communication. Sometimes they say, no, I care. But the way you express your care, it doesn't match with your verbal or non-verbal communication. मान लो आप गिफ्ट लाए हो, ये मैंने गिफ्ट रखा है या आपने टेबल पे सिंपली जाके रख दिया. अब non-verbally आप गिफ्ट तो ले आए बट verbalize तो किया नहीं. Taking the gift to the person and telling that I got you this because I I know you like it. So adding these three statements verbally adds weightage to the gift that you got for your spouse. Or verbally you said, oh, I got this lovely gift for you. और आपने bed पे रखा और चले गए. Now again, non-verbally you could just open and show it to her or him. Then styles, formal and informal. Now we all think formal is only when we come to work or things. No, formal or informal is a couple may use any language and any kind of communication between them within the bedroom, and what kind of communication and language and vocabulary they use outside the bedroom. Similarly, जैसे हम बच्चों को कहते हैं ना कि अच्छा घर में तो ये कर लो, जब गेस्ट आ रहे हैं तो उनके सामने बिहेव करना. जब हम किसी के घर जा रहे हैं तो हम बच्चों को बोलते हैं कि वहां तमीज से बात करना. It's the same thing which even applies to all of us as adults. We can all do anything within the boundaries, but when we step out of the house boundaries or home boundaries, or when a couple is in front of the in-laws, when the couple is in front of the parents, when the couple is in front of the relatives, or in any other social setting, the communication has to vary and change. You cannot have the same communication what you have in your bedroom. So what it requires now, when we try to understand the communication patterns, what is most important? Sensory ability. अगर किसी में सुनने और बोलने की क्षमता नहीं है तो communication का channel और medium everything will change. Cognitive capacity. सामने वाला जो बोल रहा है, do you comprehend? Does the other person comprehend? Especially when we talk about inter-religion or intercaste marriages, sometimes this happens. The rituals, the social ritual or practice. First of all, there may not be a sensory ability in one spouse to practice that. Even if you learn to practice, then the interpretation, how you perceive or how you interpret that particular social ritual or social practice may be very different from your own culture. And then responding ability, how you respond. Now, in beginning, if two people of different religions or different castes have decided to come together, then definitely there has to be a responding ability to either adopt each other's culture or letting each other be in their own culture without interfering or expecting the other person to adopt your culture. But that communication has to be done verbally to avoid any conflicts and communication gap. And sometimes the couples are ready to adopt, but the way the efforts or the behaviors that they are following sometimes don't sync well. That means there is a gap in verbal and non-verbal language, or there is a gap in intent and action. So now when we work on the teaching the communication skills, we give small exercises. We teach them listening exercises where they have to spend time together and just listen. So we give them observation. There's a model of observation with 4 steps. So we teach them about what you observe. For example, there's a doorbell and your spouse walks in with 5 packets. तुमने देखा है, observe कर लिया, but तुम्हें पता है कि if I take these 2 packets, I can help my spouse. Simple thing like that. Questioning yourself, I should have helped her. मुझे पकड़ना चाहिए पैकेट के नहीं, when I can see कि the other person is holding 10 packets. Analyzing immediately and evaluating, okay, कौन से वाले 2 पकड़ने? अब मान लो आपने 2 वो पकड़े कि जिससे अगला गिर गया. So of course, in a way your intention was to help, you helped also, but it led to a conflict. So evaluating which 2 packets finally I should hold that I genuinely end up helping the other person, and then speaking and gesturing. Finally. Now, interpersonal skills also we've spent, like I said, that, we work on these 2 theoretical concepts, perspective taking and emotional intelligence. We use 2 of these concepts to teach interpersonal skills, knowing what you want. When a friend calls me, okay, let's go for an adventure sport, I ask myself, do I want to go? Why am I going? So identifying what you want, asking that why I need it. No, I went last month. So do you think I need another break this month? Then negotiating the conflicting bonds. Suppose my husband also has a conference. I also have a family trip. Now, how do we decide? We all know conferences cannot be changed. So who decides? The other person. Similarly, maybe, one person is an introvert, one is extrovert. So it doesn't mean that incompatibles don't stay together. It is about your negotiation skills, how we manage to put up with each other. Suppose one is an introvert who likes to be spending weekends at home. The other person is an extrovert, likes to be spending weekends outside. So what do you do? So in therapy, what we do, I tell them, okay, one weekend you take, 2 weekends according to husband, 2 weekends according to wife, or maybe 1 weekend according to husband, 1 weekend according to wife, 1 weekend according to children, and etc. So we negotiate. Okay, at least each of you get 1 weekend of your choice. So when there is a time to be inside home, the other spouse also stays home. When there is a time for adventure outing, the spouse who's an introvert steps out with the partner, or you do your independent activities. Sometimes we practice independent activities. Sometimes you also give couples joint activities to enhance their bonding and tolerance and adjustment with each other. So that's why they say, the couples, it's the social interaction that after many years of marriage, husband learns certain things from wife, wife learns and adopts certain traits of the husband. So this is how you influence introvert and extrovert. They influence each other. Introvert starts doing outdoor activities. Outdoor or extrovert person starts doing some of the indoor activities or behaviors or practices or hobbies. Getting information. Okay, you have a plan. Why is your plan important? No, I have this crucial meeting, so I have to leave the station. I have to be out of station. So, okay, I only had planned lunch with friends, but suppose now the friends are local and they keep meeting, then you can negotiate. But it's a very crucial interview, or if it's a job promotion, or it's something like that, then it is very natural. The one who has a social gathering will have to compromise or surrender or give up. So trying to understand, it's not about I getting what I want or you getting what you want. It is about priority. So this has to be conducted. Saying no. Very, very important. Suppose a lot of times, especially in my clinic, what I see is a lot of women, because the way they are trained to sacrifice and to give up for the family life. So they keep saying, नहीं मैं शादी से पहले बहुत कुछ करती थी, ये भी करती थी, वो भी करती थी, शादी के बाद छूट गया, उलझ गया. And then what they do, they blame it everything on the husband. And husband never said you give up, but they put everything as a blame to the spouse. Because of you, iski wajah se. And then of course, when you give up so much, then they start feeling frustrated. My husband still goes with friends. My husband still plays tennis. I am the one who sacrificed everything. But who asked you? Nobody. You decided to give up. You sacrificed. Very conveniently, they label it on the husband. So this kind of a thing that, okay, if you never prioritized yourself, it was your choice. So saying no, you could say no, but you did not say no. Then, sorry, there is a spelling mistake. Mutual respect for values and goals. Now, suppose if you know that, okay, my husband is over ambitious, or suppose my wife is over ambitious, then what do? How do you respect that value? Now, if my wife has a meeting or her husband has a meeting, then what do? You let the person work on the meeting or presentation, etc. When other person likes to go adventure sport, another person likes to read a book. So you allow that kind of mutual respect. Okay, this is your time, this is my time, this is our time. So we work all of this, we work through this using small exercises and tasks. Reading time, I am giving very hypothetical example, but then we assign them exercises and things. Weekend par aap ye karenge, Sundays ko aap ye karoge. Even for that matter, sometimes couples don't have time for sexual activity. So we tell them that, okay, Saturdays when you both are not working, when next day is an off, then you can indulge into sexual activity. So we work around all of this. Now, basically, negotiation is all about husband is on 1, wife is on 10. Now, if husband moves 9 steps towards wife, it is unfair. Similarly, if her wife moves 9 steps towards her husband, even that is unfair. Unfair when I say, I'm not saying it emotionally, but what will happen? The husband will start feeling, I changed myself. She did not change. I am the one who made the marriage work. Similarly, the wife will feel कि मैं तो बदल गई, उसमें तो कोई बदलाव नहीं आया, उसने कोशिश नहीं की to make the relationship work. So what we do is negotiate. You take 3 steps, she take 3 steps, and you find a midway. You find a negotiate. Similarly, कि मुझे तो जी संडे को एडवेंचर स्पोर्ट पे जाना होता है, but आप हर संडे एडवेंचर स्पोर्ट पे नहीं जा सकते हो, because you have other people living under the same roof with you, and you do have a responsibility towards them, which you can't deny. Similarly, wife says, मुझे तो अकेले रहना, introvert हूँ, I don't like to party all the time. But then you have to start socializing because your spouse likes it, and there are other people and roles and responsibilities that you have to fulfill. So you both find a midway that, okay, you don't go every Sunday for an adventure sport, but maybe once in 1 month, once in 3 months, or something like that. Similarly, you tell the wife, okay, you can't invite people or have every weekend people over, but you have to have 1 weekend or 2 weekends to yourself, but 2 weekends you have to socialize and stuff like that. So that is what we call negotiate, where husband also gets what he wants, wife also gets what he wants. And when as an individual, my needs are met as a person, I'm happier. When I'm happier, I contribute to the relationship and the entire family environment or the home environment is happier and pleasant. But when I keep sacrificing, which so-called is called sacrificing, it only builds frustration and then people burst. Usually the techniques we use is joining and accommodating. Accommodating, like I said, we determine, okay, ये वाला Sunday आपका है, अगला Sunday husband का है, ये Sunday wife का है. Enactment. So then sometimes we help them to start talking. बोलते हैं जी बात नहीं करता. So we make them small role plays. कि आप ये करोगे, आप ये घर पर जाके 5 या 15 मिनट चाय के लिए इकट्ठे बैठेंगे और उसमें पूछोगे कि तुम्हारा दिन कैसा गया, दूसरा भी पूछेगा तुम्हारा दिन कैसा गया. So to start communicating and understanding and empathizing with each other. Structural mapping, especially in working couples, sometimes we have to do structural mapping कि ये वाला काम ये करेगा, ये वाला ये करेगा. So like I had this couple, they said कि kitchen में जब मैं काम करती हूँ, he comes, I don't like it. So we draw that boundary कि when she is in the kitchen आप नहीं जाओगे. Or when he is doing this कपड़े धोने का काम, then you will not go. So structural mapping, we try to understand जो उनके common conflict areas हैं, we try to delineate that. Highlighting and modifying interactions. So what we जो ये communication वाला loop है, we use this here actually. Highlighting and communication. Modifying. मुझे चाहिए, suppose like I said कि मुझे वो देना. अब जब आप वो देना कहोगे तो ऑटोमेटिकली अपनी अजम्पशन है सामने वाले की, पर अगर आप बोलोगे कि मुझे रेड बॉटल देना तो आप कम्युनिकेशन गैप कम कर रहे हो. दिस इज अ वेरी वेरी concrete example, but of course it is not that simple. So we usually give them a record to maintain. Husband ने क्या कहा, आपने कैसे रिएक्ट किया, तो फिर हम एक ऐसा ही दूसरे को देते हैं, वाइफ ने क्या कहा, आपने कैसे रिएक्ट किया. So this kind of a record helps us to understand who is hurting and what kind of words are you using. So we change the communication pattern, what message you want to give. मतलब आप दिखाना तो कंसर्न चाह रहे थे मगर आपने चिल्लाकर बोला. अब अगर चिल्ला के कंसर्न बोल रहे हो तो वो पॉजिटिव इमोशन तो नहीं दिखेगा, मगर आपका जो एंगर है उसको दिखा, उसने सिर्फ आपके नेगेटिव इमोशन को इंटरप्रेट किया. बाउंड्री मेकिंग इन रिलेशनशिप, realigning your goals with the husband and wife. We realign, and sometimes even children, because a lot of times we see couples who are having conflicts because of the children or because of in-laws and parental figures around. So we realign and make boundary for mother, father, child, children, their roles, and husband and wife. Challenging unproductive assumptions. मुझे लगा तुमने ऐसा कहा. अब वो मुझे लगा को जो assumptions हैं, which is in your head, we make it very concrete, verbalized communication put in the words, so that the communication gap is minimized. And finally, the outcome we try to enhance is boundary setting in a family, communication, support, socialization. We do give exercises. And biological functioning, रात को मेरा husband phone पर लगा रहता है, रात को मेरी wife सारा दिन phone पर लगी रहती है. So we do work, खाने का time गड़बड़ है. So we do work, the basic biological needs of all the members are met on time. Psychological needs, make sure that giving them family time together. Educational needs, education could be especially education of children, value teaching. Education doesn't mean only school teaching, even the values. If the husband says okay, no, I am too busy, I can't spend time with children, but that's not an explanation. So we introduce quality time. If you can't spend time every day, at least once a month you spend 2 hours with your child. Again, because we understand life has challenges, so we try to fit things into the ongoing routine. Safety, of course. And then recreational activity, which is very important. If you can go as a family once in 6 months, once in a year, and even if you can't financially afford, because we get patients of all strata, simply going to a park with your food made and having a picnic there. Then religious practices, cultural practices, and social norms of the family. So this is how we try to assess the outcome of our intervention. And with that, I would like to end my presentation. Thank you.
Thank you so much, Arju Gupta.
Thank you, sir.
It was like an open heart surgery being performed on couple therapy in communication skills as such. I'm sure the communication skills play a significant role in building up happy families, happy children for that matter. It is time for us to hear Honorable Justice Meenakshi Mehta. She has been throughout this particular session with us, and we are keenly looking forward to her observations in regard to particularly this session. May I request Justice Mehta to kindly share her thoughts on this particular important topic. Justice Mehta.
Thank you, Dr. Gupta. And once again, thanks for making me a part of this event. I must appreciate that Ms. Arju spoke so well. She elaborately discussed all the aspects and intricacies regarding the family disputes and the way these can be sorted out with the help of a counselor, and how they actually work when they are on the job of trying to resolve the things between two erring people who share emotional as well as social and legal bonds also. Family dispute, as the term itself suggests, it's a dispute unfortunately arisen between two or more people, mainly the parties to the matrimonial alliance, although other affairs are also attached to the same. But it is very unfortunate situation where two people who are so closely related to each other, somehow due to some misunderstanding or ego clash or maybe whatever any other factor, they are on the path of falling apart. So in earlier times, when there was joint family system prevalent, the elders in the family, they used to take the task of counseling the conflicting persons to arrive at some amicable settlement and to persuade them to live peacefully and coexist peacefully in the entire family. But since the nuclear family system is in vogue these days due to certain kind of changes in the times and the lifestyles, so nuclear families suffer on this count in the way that when there are conflicts or differences of opinion between the members, two members to the matrimony, none is there to tell them who went wrong where and how one can correct or rectify the error also. So it's not a guarantee that if someone is very well educated or very intelligent, then the person is never going to have any conflict in the family or especially in the marriage bond. It's all about one's perspective, or rather, I would say the perspective of both the partners to take the things in the correct way that ultimately leads to such kind of friction and conflict between them. It is said, and I think it's true also, this is matrimonial bond is the strongest one and the most delicate one also. It needs efforts from both the sides to make it a success. It needs participation from both the sides to make it a success so that they themselves as well as the family members associated with them, particularly the kids who are otherwise generally the silent sufferers of such conflicts, they should come to the terms and at least for a peaceful living, whatever is the minimum required and expected from them, they should learn that they should go by that. And as Ms. Arju was explaining the things, now the counseling comes into picture because nuclear families are there, so people need to go to the counselor only what they do, as Ms. Arju said, that they identify the problem. They identify the problematic point in their relationship, and then they try to crease out the things. So with the ever-growing number of the family disputes and people knocking the door of the courts, there came Family Courts Act in 1984. It was enacted with an object to effectively resolve the disputes between the couples, mainly couples, and other family affairs and other matters attached therewith. So basically, it was the act, it was the enactment which created family courts in the district judiciary level and all. So we are having family courts in both the states and UT also. So there is a provision like Section 6 in the Family Court Act 1984, which provides that there would be counselors for assisting the family court in discharge of its functions. It is already there, and High Court has also framed the rules in 2005, providing therein for the participation of the counselor. That shows the importance attached to their role in resolving the disputes amicably, because these are the kind of disputes where the decision on merits is not a healthy way of solving the things. These are brought with the view, the family courts have been established with the view to make all the endeavors, all the efforts to keep the family unit intact. Section 9 of the Act specially speaks for this, and we find an analogous provision in Hindu Marriage Act itself in the form of Section 23, subsection 2, where a duty is cast upon the court concerned to make all the efforts to reconcile the matter between the conflicting parties. So that is how the role of the counselor gains importance here, because maybe with the reason that when counselor takes the charge of doing the job for making best endeavors to resolve the things between the parties, then the atmosphere is quite different from that of a court. Although the courts are also supposed to hold the proceedings in camera if the court so desires, or if any of the parties request for the same. But still, when they are with the counselor, the atmosphere, the environment is entirely different. They can pour out their real feelings before them without lesser reluctance and hesitation. So that is how, and moreover, the counselors, being the experts of the field, they can understand their problems in a better way, in the right perspective. They can identify better. They can find out solutions better than that is done in the court. So that is how the counselor can effectively help in resolving the matters between the parties of this, in the cases of this particular category. So whatever Ms. Arju has said, actually that should be the part of the counseling, and that has been the part of counseling so far as my perception goes. And many a times it ends in success. And then even for the presiding officer of the court, besides the counselor, no feeling can be better than that of having resolved a dispute and having them arrive at some amicable settlement this way or that way. So this is all about counseling these days, and as I feel and I perceive that counseling is must in each and every case, although the court has to make its own efforts to get the matter reconciled between the parties, but the counselors should always be there, and in almost each case they should play their active and positive and effective role to solve the things so that the basic purpose of enactment of Family Courts Act 1984, that is to keep the family unit intact and to resolve the disputes amicably, that we can keep intact, and we can upkeep the same. Therefore, I don't have to say much about the procedure adopted by the counselor, because Ms. Arju has done it the best way possible. So thank you once again for making me a part of the event. And with that, I finish up my thing. Thank you, everyone.
Thank you so much, Justice Mehta. You have shared your thoughts on this very important aspect of family disputes. The role of the counselors, in fact, is important. Even yesterday, Justice Ritu Bari specifically focused on that in her opening remarks in the second session. You know, the counselors can play a good, significant role, but ultimately the couples have to realize their own responsibility as such. You know, the both sides must understand each other. Counselors can play a role in bringing that understanding between the two for that matter. The lack of communication focused by Arju Gupta also, you know, basically give and take accommodation plays a significant role in building up happy couples, happy families for that matter. And therefore, each one has to understand and play the role. With this, we would conclude this particular session. Time in the morning today. I also thank Arju Gupta for making this presentation meaningful, wholesome presentation as such. So very kind of you. I would request the judicial officers participating in this workshop to fill up the feedback forms so that we can have your feedback in this particular context of the workshop. Thank you so much. Sir, good. Everyone, we start with the second session of the day. This session is dedicated to determination of best interest of children, family disputes, issues and challenges. For the opening remarks, we have with us Honorable Mr. Justice Anupinder Singh Garewal, who is a blend of the bar and the bench. He joined the bar in the year 1992. He was appointed as the Additional Advocate General in the year 2005. He was elevated in the year 2014. 22 years at the bar, and now 8 years as a judge of the Honorable High Court. Judicial education normally means providing opportunities to the young judges to have the experienced judges sharing their experience with the younger judges. And therefore, the rich experience that the measuring rod for carrying out this particular session. May I request Justice Kariwal to make the opening remarks for this particular session. Over to Justice Kariwal.
I am thankful to Dr. Gupta for giving me the opportunity to participate in the workshop on family courts. The topic of discussion in this session is of immense significance. The law on the subject is evolving, but considerable progress has been made in recent times. And you have the domain experts who will be delineating further on the subject. I would just narrate my experience. The first brush I had with the concept of shared parenting was when I was a student in Delhi in the 1980s. One of my classmates was staying with his mother in Delhi. The parents had separated. The father had even remarried. But the mother and the father, they were in regular touch, speaking to each other on the phone, sharing the concerns about the well-being and upbringing of the children. One of the children had to undergo a minor medical procedure. The father came all the way down to Delhi, and both the parents were there when they took the child to the hospital. And in the evening, they would have dinner together. The father was staying elsewhere, but they would have meal together. The entire family is there. That's how I got to know this concept of shared parenting. And both the children, they developed into responsible citizens with well-rounded personality. But when I started practicing in Chandigarh, I didn't have a very good experience when I saw some bitter custody battles over the children. I will just narrate recently, there was a petition for habeas corpus which had come up before me at the instance of the mother. She was present and she was, of course, she was disturbed, understandably so. And she would not even allow her lawyer to speak. She would say, my child has been taken away, straight away, give me the custody. So I tried to give her a patient hearing, tried to reason with her and told her, let's try mediation. She was opposed to it. Even the lawyer for the other side also came. They were also hesitant, but then with some persuasion, I was able to send them for mediation. And after mediation, then they said some progress has been made, but lots. I said, if some progress has been made, we go to give it another shot. Then I kept it for a day-to-day hearing, and it gave me immense satisfaction when the matter was resolved. The custody, of course, with the mother and with visitation rights and periodic and whatever was mutually agreed upon. I mean, that gave me a lot of satisfaction. So what I intend to say is that the family courts should deal the matter with a lot of patience and sensitivity. It's not like an ordinary legal dispute to be decided after hearing arguments and close. It has to be patiently, and we need to, I think, strengthen our mechanism. We are already doing it for counseling and referring such disputes for mediation. Because even in pandemic, I believe the parent, in some cases, of course, who had the custody of the child has tried to deny the visiting rights to the other parent. So these disputes also need to be resolved. And now this concept, now the concept of best interest of the child has to be adjudicated while keeping in view the interest of the child, which is of paramount importance, rather than the interests of the parents. Normally what happens is the parents are going to have the custody or visiting rights as per their convenience. Of course, their convenience has to be addressed, but there are other issues. And the Supreme Court also, I think both the experts are there. They'll be referring to the judgments in detail. There is the Supreme Court in the case of Vasudha Sethi in 2022 has held that a child's welfare and not the individual or personal legal right of the parents are of paramount importance in a custody battle. In fact, the welfare of the child must get precedence over the parents' rights. Then there are other judgments also. This Vivek Singh versus Romani Singh, the Supreme Court highlighted the concept of parental alienation syndrome, which refers to the unjustified disdain of a child towards his or her parents, which very often happens. They are using the child as a pawn, and sometimes one parent is trying to tell the child about, that in a way, the image of the other parent is shown in a negative light. So not realizing that in the process, the child is suffering. So these issues, now the family courts are well equipped. Now they can even devise their own procedure to some extent to resolve these disputes. I think other aspects are there for our experts to delineate. Mr. Anil Malhotra, of course, is a domain expert and very well, widely acclaimed internationally. And Mrs. Madhu Khanna Lali has got experience, judicial experience in deciding such cases. And of course, won't take much time. I hope I have not overshot my mark. So thank you very much.
Thank you so much, Justice Kariwal. You have focused the issue as such. Ultimately, in deciding, adjudicating all these issues, what is in the best interest of the child is of paramount importance. And I'm sure the two presentations this morning that we are going to have, one from Mr. Anil Malhotra and the other from Madhu Khanna Lali, are going to focus on the different aspects relating to the best interest of children. In this particular context, I thank Justice Kariwal. I know you are busy and therefore be so very kind of you to be with us this morning, and we look forward to your association in our future programs as well. Thank you so much. I would now request, in fact, I had introduced both Anil and Madhu yesterday, and since they are sharing the session today again, I would now request Mr. Anil Malhotra to proceed with his presentation in this particular context. Over to Anil.
Thank you, sir. Honorable Justice Kariwal, Lord Denning, Dr. Balram Gupta, and my learned esteemed colleague, Judge Madhu Khanna Lali, and Kartas of the judiciary, the legal guardians of children. Who is a child? Is a child a person who is an entity under 18 years of age? I would say no. Child is the father of man. From that perspective, if we look at a child, let us first go to the nitty-gritty of the very basis of the concept of the best interest of the child, since the topic session is determination of the best interest of the child. Now, India signed the United Nations Convention on the Rights of the Child in 1992, wherein a child was considered to be a person with a right to life, right to a nationality, right to a home, right to a family, and so on and so forth. India crystallized all these rights piecemeal way in different legislations, but the real legislation came when India amended the Juvenile Justice, Care and Protection of Children Act. First it was of 2008, then it was of 2010, then ultimately came the Act of 2015. Now, a lot of us do not know that the only legislation which defines the best interest of the child is Section 2, subsection 9 of the Juvenile Justice, Care and Protection of Children Act 2015. I would like to read this definition because it took me almost 10 years to convince the Delhi High Court to start with, and then ultimately the Supreme Court, that this is a definition you have to look into, because none of the personal law legislations or the Guardian and Wards Act defines what is the best interest of the child. So the simple meaning of the definition of the best interest of the child, which has been picked up in a wholesome way from the entire collection of rights emanating from the UNCRC, are given in this subsection. Now, once India signed the UNCRC, it was obligated to incorporate in domestic laws whatever was contained in the convention to give force or give teeth to the meaning of the convention. So, best interest of the child means the basis for any decision taken regarding the child to ensure fulfillment of his basic rights and needs, identity, social well-being, and physical, emotional, and intellectual development. So this is the wholesome definition of the best interest of the child. Now, when I engaged in this argument, the objection of the bench and of the opposing counsels were that the JJ Act is an act which applies to children in conflict with law. But then, the JJ Act also applies to children in need of care and protection. Now, one of the categories of the children in need of care and protection are children or a child who resides with a person, whether a guardian of the child or not, and such person has injured, exploited, abused, or neglected the child, or has violated the rights or any other law for the time being in force meant for the protection of the child. So when a parent decides to take singular custody of the child, the rights of the child are being violated. So therefore, the child is a child in need of care and protection. And therefore comes the definition of the Juvenile Justice Act, the best interest of the child. Now, when I urged this expression to be taken note of in habeas corpus petitions in the Delhi High Court, first of all, I was able to convince the division bench headed by Justice Vipin Sanghi. Then I was able to convince the bench of Justice Spani. And ultimately, this concept was accepted when I urged submissions before Justice Khanwilkar in the Supreme Court. And now, of course, this wholesome definition is often taken care of and is noticed. So my respectful and humble submission to honorable judges of the family courts is, please feel free to hold the scales of determination of the best interest of the child with keeping in the weights of the definition given in the JJ Act to determine what is the best interest of the child. The rights of the parties, Ashish Ranjan, Lari Sakhamuri, Ruchi Maju, Supreme Court says, are immaterial. The scales must rest on the best interest of the child. And what are your weights? What are your balancing gadgets? Is the definition given in section 2, subsection 9. So with this brief opening, in a child-centered jurisprudence, please look at the child, hold the scales to determine his best interest, leave the mother and the father apart, and determine as you would, as your conscience would allow you, to decide what is the best interest of the child. Now, to go into some concepts for a better determination, I will briefly run through some provisions of the Hindu Minority and Guardianship Act and the Guardian and Wards Act, so that the way I would look at them, I would like to explain in my way that there is a lot more that we sometimes ordinarily miss. So first of all, section 3 or section 2 of the HMGA says that the expressions used in this act and the provisions of this act are in addition to and not in derogation of the Guardian and Wards Act. So the HMGA is only a supplemental legislation. And for you as honorable judges, you know that HMGA does not contain any substantive right to take you to a remedy in a court. You have to invoke the GWA, which is an archaic 135-year-old colonial law, but that's what it is. Then comes the expression guardian. Who is a guardian? Guardian means the person having the care of the person of the minor and includes a natural guardian. So I pause here. If a natural guardian as a parent holds and has that title on him, can he be declared or sought to be declared a natural guardian to the exclusivity of the other parent? Now, this is a question which the Supreme Court has answered in Aman Lohiya's case. I will come to it later. But please pause. Can you divest a natural guardian of his responsibility, of his rights, of his duties? The answer is no. And the answer is in section 19 of the Guardian and Wards Act. You have to declare him unfit before you get rid of that statutory responsibility which he carries on his shoulders. Now, with this, I come to section 6, which is a very meaningful and a very, very important provision, because we get mixed up in vesting jurisdiction by reading section 6 of the HMGA alone. Now, I have been able to bring about this after almost 37 years in the profession, and having gone through different judgments of different courts and being before the Supreme Court, one is able to get a clearer view by reading, rereading, and expanding in a different way. Now, section 6 says that the natural guardian of a Hindu minor shall be the father and the mother. They are both equal. That is, of course, well settled by the Supreme Court in the case of Gita Hariharan. But what does it say further? Provided that the custody of a minor who has not completed the age of 5 years shall ordinarily be with the mother. Now, there is a lot said in this. On a first reading, we miss it. So first of all, a minor, on a plain reading of this, minor under 5 years of age, custody shall be with the mother. The guardianship of the father goes nowhere. So please don't mix up the two phrases. Then let's come to the word ordinarily. Now, over a period of time, ordinarily was meant to be read as shall, not may. Means ordinarily was read to be carrying a statutory mandate. So on a plain reading, the first reading you said, 5 years of age, less than 5 years of age, custody goes to mother. Now this concept has been done away with in Lahari Sakhamuri's case by the Supreme Court. I have given the judgments, so you needn't bother with the citations. But I'm going to read to you something which I was able to convince the Supreme Court after good 10 years in the High Court. I amalgamated the definition of the best interest of the child with Section 6. And the way Justice Khanwilkar expressed himself is in para 43 of Lahari Sakhamuri. The expression best interest of the child, which is always to be kept of paramount consideration, is indeed wide in its connotation. Now, the key words, and it cannot remain the love and care of the primary caregiver, the mother, in the case of an infant who is only a few years old. So the explicit exclusion and statutory mandate is not there. The word ordinarily only means the love and care can swing either way. Today I was reading in the Economic Times, all big corporate companies are granting paternity leave when a child is born. You have sit-home fathers. COVID-19 has taught us that there are parents working from home. So this has given to a new dimension of parenting and parental rights. Now, the Supreme Court further says the definition of the best interest of the child as envisaged in Section 29 of the JJ Act as to mean the basis for any decision regarding the child to ensure fulfillment of his basic needs and identify social well-being and physical, social, and intellectual development. So the Supreme Court says that the best interest of the child cannot remain the care of the mother, the primary caregiver, if the child is less than 5 years of age. So please start thinking differently. Start holding the scale with the best interest of the child, and please don't go by a first reading of the provision, because ordinarily has swung by the Supreme Court to mean something different. Now, before I move to the other issue which comes from this, I must also share with you the judgment, the words of the Supreme Court in Vasudha Sethi versus Kiran Bhaskar, decided on 12th of January 2022, where again the Supreme Court is saying, when a court decides that it is in the best interest of the minor to remain in the custody of one parent, the other parent is bound to be affected. In the case of a minor boy or girl, the natural guardian is the father, but ordinarily the custody of the minor who is not completed the age of age shall be the mother. The Supreme Court further says, on a conjoint reading of Section 1, subsection 1 of Section 13, that is the welfare of the child, and Section 6A of the HMGA, if it is found that the welfare of a minor whose age is more than 5 years requires that the custody should be with the mother, the court is bound to do so. But here comes the other side. In the same way, if interest of the minor, which is the paramount consideration, requires that the custody of the minor should not be with the mother, the court will be justified in disturbing the custody of the mother even if the minor is less than 5 years of age. So here is the writing. There is no vested right with the mother if the child is less than 5 years of age. There is no vested right of the father if the child is more than 5 years of age. Please try to adapt to these new principles which the Supreme Court has evolved in these two judgments. Kindly don't go by a first reading of the words. They are going into different connotations with the advancement of time, evolving perceptions, and with equal parenting rights. We are divided. We have gender-based thinking ingrained in us. We have to change. We have to think differently. We ought not to determine simply on the basis of the father or the mother. The child is not a table or a chair who is to be given to the mother or the father. The child is a person. Keep in mind the UNCRC. Please read the United Nations Convention on the Rights of the Child to understand what is the child needs. So in this perspective is coming one concept. Now the other concept which comes with section 6 is, which again is a blind alley, is now the mother says, I have a right to the child because the child is less than 5 years of age. Therefore, the mother says, my residence is the residence of the child. Now, I'm going to leave you with this questionnaire and finish my reading of the HMGA and come back to this question. Does section 6 determine jurisdiction in a Guardian and Wards Act petition? The straight answer is no, because the answer is in section 9 of the Guardian and Wards Act, where the minor ordinarily resides, not where the mother ordinarily resides. A lot of people get confused with this thinking and say, mother, child less than 5 years of age, custody with mother, wherever mother is living is the residence of the child. I personally feel this is the wrong connotation. There are JK versus NS has discussed threadbare these judgments after I urged to the court that this is a different connotation. There are 6 high courts on one side holding that the residence of the mother is not the residence of the child. Our high court is on the view that the residence of the mother is the residence of the child. The Supreme Court, affirming the judgment in JK versus NS, has in a way given a mandate that is the position, but there is no clear explicit view of the Supreme Court on this. So this is again a gray area for the timing. Now I want to quickly run through the remaining provisions of the HMGA. Now section 8 talks of the powers of a guardian. So whosoever has the custody, the guardian does not lose his powers. That's one. Then come to section 13, welfare of the child to be the paramount consideration. Now this is something very important. Now section 13 itself carves out the exception to section 6. So if you stop reading after section 6 and you don't read 13, you miss the bus. Now section 13 says, in the appointment or declaration of any person, the welfare of the minor shall be paramount. Then here is the bar. No person shall be entitled to the guardianship by virtue of the provisions of this act or any other law amongst Hindus if the court is of the opinion that his or her guardianship will not be for the welfare of the minor. So you fall back on the best interest of the child, the welfare of the child. So no parent has a sublime right. No parent has a vested or an absolute right. It is a subjective right. The scale is the welfare of the child. Nobody can claim exclusive priority simply because the child is X years of age or Y years of age. You have no right by virtue of being a parent. There is no superior or inferior parent. Both parents are equal. But what is the welfare of the child? How do you balance that? That is the crunch. Now, with this brief introduction of this act and the way I read it, now let us look at some provisions of the Guardian and Wards Act. Now, first of all, the Guardian and Wards Act in section 7 talks of power of the court to declare a guardian. So it says where the court is satisfied that it is for the welfare of the minor, an order should be made. It can appoint a guardian or declare a guardian. Then persons entitled to be appointed a guardian is in section 8, and any person desiring of being declared a guardian can do so. But then the question comes, if you are a natural guardian, do you need a declaration as a guardian? Now, this is something which seeks to be answered in a perspective that you cannot displace the guardian of his rights. You can only confer custody. The natural guardian's rights can never be taken away. And I come straight to the exception, which is in section 19. Section 19 says that the guardian is not to be appointed in certain cases. So it says in 19b that a minor's guardian, that is the father and mother, until and unless they are declared unfit to be in the opinion of the court, the guardianship cannot go. So please be careful when you decide guardianship rights, that the declaration of unfitness is something you have to establish on substantive evidence, and it is an unfitness which has to be established on the basis of cogent evidence. You can displace custody, you can give visitation, but guardianship is something you cannot take away by virtue of this provision. Then we come to section 12 next. Now, section 12, talking of interlocutory orders, integrum of a petition for guardianship, is very meaningful, and it gives you the power to act in a way which I am going to explain to you the way I read it. The court may direct that if any person having the custody of the minor shall produce him or cause him to be produced, and at such time as it may appoint, and may make such order for temporary custody and protection of the person or property of the minor as it thinks fit. Now, I say that the word such order and temporary custody means you are free to evolve your shared custody and joint parenting plan. So, if someone were to say to you that shared custody and joint parenting plan is not to be found in the statute, I would disagree, because I would think that such order or temporary custody is given to you by virtue of your power to pass an interlocutory order under section 12. And if we look at the Family Courts Act of 1984, your powers under section 12 and section 14 permitting you to lay down a procedure for arriving at a settlement or coming to the truth of the facts alleged by one party or the other, and then in that process taking in a document dehors the Evidence Act, gives you complete freedom under section 12 to come out at the interim stage with a direction to the parties: please prepare a shared custody or a joint parenting plan for the best interest and welfare of the child. Now, with this, I will run through briefly some provisions of the Family Courts Act, which of course may not be very elaborate for the time being now. Now, your jurisdiction for guardianship and custody matters arises from Section 7, explanation number G, a suit or proceeding in relation to guardianship, custody, or access to the minor. Now, as far as the procedure and other issues are concerned, I needn't read through it. But again, what is important is that your determination again is to rest on the best interest and welfare of the child. And again, the same principles have to be followed. Now, let us look at a judgment from a very wide perspective as to what jurisdictional issues will mean. Now, I just wish to elaborate on the concept of where the difference of opinion arises. Now, the Supreme Court in Tejaswini Gauds, that is 2019, 7 SCC 42, said that the Guardian and Wards Act, the jurisdiction of the court, is determined where the minor ordinarily resides within the area of the court exercising such jurisdiction. So, Section 6 of the Hindu Minority and Guardianship Act does not determine jurisdiction. Now, the second judgment on the point is Ruchi Maju. Ruchi Maju is the Bible and Jurisdiction, 2011, 6 SCC 479. Now, Ruchi Maju says, in cases arising out of proceedings under the Guardian and Wards Act, jurisdiction of the court is determined from where the minor ordinarily resides within the jurisdiction of the court. There is a significant difference between the jurisdictional facts by a writ court and by a Guardian and Wards Act court. And then, para 62, the crunch, it says, it does not hold much persuasion, it does not require much persuasion to hold that whether the court should examine the matter or not will rest on the fact that the court, which has no jurisdiction to entertain a petition, cannot pass any order with respect to the return of the child. And the party may be required to invoke the jurisdiction of the appropriate court. Now, in this case, the Supreme Court says that a court that has no jurisdiction to entertain a petition for custody cannot pass any order or issue any direction for the return of the child. The party aggrieved must seek remedy before the court legally, remedy open to it legally, but no redress can be made for the court which has no jurisdiction. Now, if we look into this provision carefully, minor ordinarily resides has to be read in for jurisdiction. So, the residence of the mother has not to be read in into the conferment of jurisdiction under Section 9 of the Guardian and Wards Act. Section 6 is not, HNGA is not the determining provision. Section 9 of the GWA is the determining provision. Now, what does minor ordinarily reside mean? It means n number of judgments say where the child continuously and habitually resides, not residing at a place where the child is present on the date the petition is filed. It is not a place where a child is removed by force or brought for the filing of the petition. So this is again your judgment to determine where is the child residing, where is the child going to school, which is his home, which is his habitual place of living, and so on and so forth. If you find that the child is not residing in your jurisdiction habitually, ordinarily, and permanently, the petition has to be declined. You can do so by a preliminary issue. You can do it in an Order 7 Rule 11 application, or the best way you think fit. But Ruchi Maju says you have no jurisdiction, and Tejaswini God is very clear that the determination of this has to be done on the anvil of Section 9 of the GWA and not on Section 6 of the HNGA. So this is one very big hurdle which needs to be clarified and which needs to be explained in the perspective of the jurisdictional issue. Now, having said that, the bigger, larger picture of what should be your method and procedure of handling a Guardian and Wards Act petition is best laid out in the latest judgment of the Supreme Court in Aman Lohiya's case. This is 2021 SCC Online SC 224. I have circulated this judgment. Now, this was a case where I had argued the matter before the Supreme Court, and it had a very interesting set of facts. The petitioner before the Supreme Court was also the applicant of the petitioner before the family court in a guardianship petition. He was unsuccessful in getting the visitation, access, and custody of his child. before the family court. He took the unlawful route of taking the child out of the country by Bagdogra, Nepal, and then going to Dubai and converting to Muslim religion. The matter went to the High Court in a habeas corpus petition. He did not appear. Criminal contempt proceedings were initiated against him. He was held to be guilty of criminal contempt. Ultimately, a team of CBI was sent to bring him back. The matter was urged before the Supreme Court in all those matters. The criminal issues are still pending. But then the family court's decision, meanwhile, was that it permitted the mother to transpose in place of the father as a petitioner. And on one date of hearing, the family court not only transposed the mother as the petitioner, but also gave her exclusive guardianship rights. This order was questioned by the father in an appeal before the High Court. The Supreme Court transferred the appeal to its board, and it expounded on the jurisdictional aspects of how a family court ought to determine a guardianship petition. So the Supreme Court did lay down, but I want to dwell on para 25 of the Supreme Court judgment dated March 17, 2021. Now, which is very important from you, for your point of perspective. It says, as a matter of fact, in the Indian context, the provision of the 1984 Act nor the 1890 Act envisage a direction in favor of the parent to be declared as the sole, exclusive, and absolute guardian and custodian of the minor. Such declaration has been intentionally obtained by the respondent from the family court to serve an ulterior purpose. Then the appellant has taken us through the points to buttress the argument that the respondent is not a fit person. According to the appellant, the father, being the natural guardian under Hindu law, is entitled to a declaration of guardianship unless it is found in a given case that is unfit in the context of parenting of the minor child or would be against the interest and welfare of the minor child, as the case may be. According to the appellant, the father is the natural guardian, irrespective of the mother's custody. The guardianship of the father cannot be divested to buttress his contention reliance placed on so-and-so. It is contended that unless and until the father is declared unfit, the relief of declaring him to be guardian cannot be declined. The fact that the appellant had taken the child away from the jurisdiction of the family court does not mean that he was the kidnapper of the child and he continues to be the natural guardian. So the point which I'm trying to bring home is that if a declaration has to be given to you by you declaring a parent as the natural guardian exclusively, unless and until you declare the other parent as an unfit parent, this declaration cannot be given. You can share the custody, you can give exclusive custody, but parenting rights cannot be divested or given away in this process. Now, the second important point which this judgment brings home is in paras 36 to 40 onwards, where the Supreme Court says there is a mandatory procedure for you to follow. A family court is not a writ court. So whatever is the mandatory procedure of pleadings, coining issues, then recording evidence, then coming to a conclusion, giving opportunity, you have to fulfill. Now, the argument of the other side was that CPC and Evidence Act can be given a go by. But the Supreme Court's rebuttal is you cannot obviate, you cannot dispense away with statutory procedure. You have to follow the statutory procedure and then you can coin your own procedural aspect for leading of evidence, meaning thereby if you want evidence to be sworn in, you can take by way of affidavit the examination, and the cross-examination can be verbal. It saves time, it's quicker. It's very common in Delhi to give a pen drive giving an affidavit so that time is saved. The judge can read through the evidence while the cross is being conducted by the opposite side. Obviously, the pen drive containing the affidavit is already served to the opposite party in advance. But I have done trials in 6 months where the court is able to finish it off if helpful expedited procedures are adopted. But this is something you have to devise within your own court to come to these issues. Now, the next thing which the Supreme Court says is abandonment should not be inferred. Transposing should not be entertained ex parte. Opportunity should be given. Now, these are important points which you can go through at length. Substantial non-compliance of procedure cannot be done away. Fitness of the appellant to be decided on merits. Now, the ultimate relief the Supreme Court was awarded was it set aside the order of the family court, remanded the matter back to the family court, but it has laid down in a detailed way the procedure which is mandated to be followed under the Guardian and Wards Act and the Family Courts Act. So this is something on the jurisdictional issue. Now, I know I'm short of time, so I will very quickly cover three different aspects which I think need focus. Now, the first is your approach in a guardianship petition should be a child-centric approach. Do not be misled by parties converting it into a divorce petition or an attack on each other of marital rights. When people talk of marital rights, you can ask the counsels to refrain from referring to the pleadings. In Kiran Bhaskar's case, which I just read, I was an amicus before the Supreme Court. There were 2,000 pages of allegations by the parties against each other when we were looking at the child. So the judge said, I'm not going to look into anything. And he asked me for a balanced view. So I gave a report and we looked at the issues concerning the child and we came out with something of a joint parenting plan. And that's how we were able to come out of it. You have a power to appoint an amicus. It's in the act. You have the power to take assistance. Feel free. Appoint in Bombay. There is a child independent lawyer. There is a panel of 30 lawyers maintained by the court. And out of that, they pick up a lawyer for the child. And the judge sometimes only hears the lawyer for the child because left and right is only allegations. So the child independent lawyer seeks the report of a counselor and comes out with an answer. And then the matter goes forward. Now, I personally feel the way out is in section 12, you have a power to make an interlocutory order. Now, the word such order means you can tell the party, I'm not going to proceed with the matter till you come up with a shared parenting plan or a joint parenting plan. If somebody wants custody, tell him you will have to bargain for custody on Saturday and Sunday. If one parent wants only visitation, give him visitation, balance it, and come out with a joint parenting plan in the beginning so that the litigation can proceed smoothly thereafter. So a child-centric approach is something which is very necessary and which has been laid down in Ashish Ranjan's case and in Ruchi Maju's case, where the judge says, where the court says, Supreme Court says, it is very necessary for this issue to come forth in that way. Now, the concept of a joint or a shared parenting plan is found in Tushar Obale, Supreme Court, Bombay High Court, Karnataka High Court judgment in Sitaraman's case, Kiran Bhaskar R High Court, in JK versus NS in the Delhi High Court. Now, this is something which is not an alien concept. Please don't feel that shared parenting or joint parenting is not a word used in the act, and therefore you don't know how you will resolve it. You have to read into the word section 12. In section 12, I'm going to just very quickly emphasize on those words again so that they stick to the mind. So section 12 of the section 12 of the Guardian and Wards Act says the court may make such order for temporary custody. So such order means shared custody order. Temporary custody means joint parenting plan. So extend the interpretation of these words, and with the freedom you have under section 12 and section 14 of the Family Courts Act, you can devise a procedure of your own. It's not alien to you. And you have judgment of Tushar Obale, Bombay High Court, Sitaraman Rama was in Karnataka High Court, JK versus NS, Delhi High Court, Kiran Bhaskar, Justice Tyagi's judgment, which very clearly says nothing in this order shall prevent the parties from adopting a joint parenting plan as agreed to in the welfare of the parties for whatever reason. So in the best interest and welfare of the child, being the paramount consideration, you can pick it up and you can adopt that method. Now, what is the fallout and the negative side of this if you don't do it? Vivek Singh versus Rumani Singh. Justice Sikri identified parental alienation syndrome as a serious disorder, and the WHO now classifies it as a psychiatric disorder among children, where a child polarized or alienated by virtue of missing contact with the other parent starts feeling that the other parent is bad, he is tutored or taught by the other parties. I saw this very seriously in a case which I must narrate to you in just a minute. There was a couple belonging, I will not name the city, in Haryana, whereby they had parted company because the man was traveling up and about. So the mother took the children and went to her maternal home, and the father, upon realizing that he could not find them, tried to contact her, and she told him that I'm in a foreign country. So he applied to the country and got a visitation right. So he was supposed to talk to the child, but because of the time difference, the child was always asleep. There were two children, the other child was all right. So one day he noticed a fan rotating on the ceiling. So he got suspicious. He landed up at the home, the maternal grandparents' home, and he found his child there. So when he tried to recover the child, there was an altercation and an ugly issue resulted. So he came to the High Court in a habeas corpus, and the court was able to order that the child should be returned to the father. But then during the course of the proceedings, he tried to talk to his other child who was with the mother. And the child was using very abusive language for an 11 or a 12-year-old. And that was a clear import that the child was being tutored. So parents will tend to use children as their pawns and influence them in such a way that they get polarized or they get affected to be on one side. Now, this is a very negative aspect, and it needs to be handled very gently. So, looking at this entire circumference, I now pass the baton on to the Honorable Judge, who perhaps is better trained than me because she's on the other side, I am on this side. So, with this brief narration of mine, I wrap up and I pass the baton back on to Dr. Gupta.
Yes, now Madhu can start with the presentation.
Thank you, sir. Good afternoon, everyone. I think we are already running very short of time, so I'll have to speed up. It's a privilege to speak on this platform again. Childhood is not a race to see how quickly a child can read, write, or count. Rather, childhood is a small window of time to learn and develop at the pace which is right for each individual child. In 1893, Lord Lindley Justice had observed that the dominant matter for consideration of the court is the welfare of the child. But the welfare of the child is not to be measured by money only, nor by physical comforts only. The moral and religious welfare of the child must be considered as its physical well-being, nor can the ties of affection be disregarded. Custody of a child refers to the right given to a parent by the court to look after the minor child. Child-supported visitation rights also have a positive effect on the child. Frequent meetings with non-custodian parent will make him believe that he is still close to his parent. When the child will receive emotional as well as financial support from non-custodian parent, it will certainly develop a strong bond of love and affection between them, and also instill a sense of security and comfort in the child. Now, as has already been discussed by Mr. Malhotra, the statutory law which is prevalent in the country is the Guardians and Wards Act 1890, which is the common law that provides remedies for parents undergoing custody battles after divorce. The Act pertains to general law, irrespective of the religion of the parents, whereas Hindu Minority and Guardianship Act 1956 deals with certain parts of law relating to minority and guardianship among Hindus. Now, Section 6A of Hindu Minority and Guardianship Act has remained in controversy for a long time, since the plain reading of the law portrays that father is the natural guardian of the minor, and after him, the mother could be the natural guardian. Thus, on the face of it, the subclause violates the doctrine of equality enshrined in Articles 14 and 15 of the Constitution. In Geeta Hariharan's case, Geeta Hariharan versus Reserve Bank of India, 1999, Volume 2, SCC 228, the question arose as to whether Section 6A of the Act discriminates between father and mother on the sole basis of sex. The Honorable Apex Court observed that whenever a dispute concerning the guardianship of a minor between the father and mother of the minor is raised in a court of law, the word after in the section would have no significance, as the court is primarily concerned with the best interest of the minor and his welfare in the widest sense while determining the question as regards custody and guardianship of the minor. The father continued, I'll just discuss a little bit more on that. By majority view, the Honorable Supreme Court interpreted the word after in Section 6 as not necessarily meaning after the lifetime. It rather means in the absence of. The word absence referring to father's absence from the care of the minor's property or person for any reason whatsoever. Now, example can be if father is wholly indifferent to the mother of the minor, or by mutual understanding, mother is made in charge of the minor, or father is physically unable to take care of the minor, either because he is staying away or he has physical or mental incapacity. Now, the problem that emerged was how to address the situation where no one is at fault. The father continued to have a preferential position when it comes to natural guardianship, and the mother becomes a natural guardian only in exceptional circumstances, as the Honorable Supreme Court has explained in Geeta Hariharan's case. But with the passage of time through various judicial pronouncements, it is established that all statutory guardianship arrangements are ultimately subject to the principle contained in Section 13, that is the welfare of the minor is the paramount consideration. Now, what are the factors which have to be considered by the court when appointing guardians? These have been enumerated in Section 17 of the Hindu Minority and Guardianship Act 1956. And the court has to take into account the age, sex, and religion of the minor, the character and capacity of the proposed guardian, and how closely related is the proposed guardian to the minor, the wishes, if any, of the deceased parents, and any existing or previous relation of the proposed guardian with the person or property of the guardian, of the minor, And Section 17(3) clearly stipulates that if the minor is old enough to form an intelligent opinion, the court may consider his or her preference. Now, this was under the Hindu law. Under the Muslim law, the father is the natural guardian, but custody vests with the mother until the son reaches the age of 7 and the daughter reaches puberty. Muslim law is the earliest legal system to provide for a clear distinction between guardianship and custody, and also for explicit recognition of the right of the mother to custody. The concept of hizanat provides that of all persons, the mother is the most suited to have the custody of her children up to a certain age, both during the marriage and after its dissolution. A mother cannot be deprived of this right unless she is disqualified because of apostasy or misconduct, and her custody is found to be unfavorable to the welfare of the child. In judicial decisions under the Guardian and Wards Act involving Muslim children, courts have sometimes upheld the mother's right to custody over children under Islamic law, and on other occasions have given custody to the mother out of concern for the welfare of the child. The important citations can be noted down. This is Soharabi versus D. Muhammad, AIR 1988, Kerala 36, where mother was authorized to have custody of a daughter of 1.5-year-old age. Then Muhammad Jameel Ahmad Ansari versus Ishrat Sajida, AIR 1983, AP 106, where the custody of an 11-year-old boy was given to the father on the ground that Muslim law allowed the mother to have exclusive custody only until the age of 7. In Muhammad Begum versus Mubarak Hussain, AIR 1986, MP 221, where the Honorable Madhya Pradesh High Court interpreted Mohammedan law to allow custody for the mother. Now the question arises, who has the priority claim to the custody of a child? This has already been discussed that the welfare of the minor is the only consideration, irrespective of the claims of the parties to the custody. The court is not required to take into consideration whether from any other point of view, the claim of the father in respect of such custody or upbringing is superior to that of the mother, or the claim of the mother is superior to that of the father. In relation to the custody or upbringing of a minor, a mother has the same rights and authority as the law allows to a father, and the rights and authority of mother and father are equal and are exercisable by either without the other. Each case has to be decided on its own facts, and other decided cases can hardly serve as binding precedents insofar as the factual aspects of the case are concerned. Better financial resources of either of the parents or their love for the child may be one of the relevant considerations, but cannot be the sole determining factor for the custody of the child. In fact, no statute on the subject can ignore, eschew, or obliterate the vital factor of the welfare of the minor. This was discussed in a case titled Mausami Moitra Ganguly versus Jayanti Ganguly, AIR 2008, Supreme Court, 2262. Now, absolute right of parents over their destinies and lives of their children in the so that they may grow up in a normal, balanced manner to be useful members of the society, and the guardian court in case of a dispute between the mother and the father is expected to strike a just and proper balance between the requirements of welfare of the minor children and the rights of their respective parents over them. Now we are talking about welfare. Mr. Malhotra has, of course, explained the meaning of welfare, but I'll take the liberty to discuss this again. In case titled Neel Ratan Kundu versus Abhijit Kundu, 2008, Volume 9, SCC 413, the meaning of the term welfare was explained, and it was held that a court, while dealing with custody cases, is neither bound by statutes nor by strict rules of evidence or procedure, nor by precedents. In selecting proper guardian of a minor, the paramount consideration should be the welfare and well-being of the child. In selecting a guardian, the court is exercising parents' patria jurisdiction and is expected, rather bound, to give weight to a child's ordinary comfort, contentment, health, education, intellectual development, and favorable surroundings. But over and above physical comforts, moral and ethical values cannot be ignored. They are equally or even more important, essential, and indispensable considerations. If the minor is old enough to form an intelligent preference or judgment, the court must consider such preference as well, though the final decision should rest with the court as to what is conducive to the welfare of the minor. Then in Sarita Sharma versus Sushil Sharma, 2000, Volume 2, RCR Civil 367. The Honorable Apex Court held that Section 6 of the Hindu Minority and Guardianship Act constitutes father as a natural guardian of a minor, but that provision cannot supersede the paramount consideration as to what is conducive to the welfare of the minor. The crucial factors which have to be kept in mind by the courts while deciding the welfare of the children has been discussed in Lahiri's Sakhamuri versus Sobhan Kodali, 2019, Volume 7, SCC 311. So what is essential is maturity and judgment, mental stability, ability to provide access to schools, moral character, ability to provide continuing involvement in the community, financial sufficiency, factors involving relationship with the child as opposed to characteristics of the parent as an individual. Then in Tejaswani Gaur versus Shekhar Jagdish Prasad Tiwari, 2019, Volume 7, SCC 42. It was held that the welfare of the child shall include various factors like ethical upbringing, economic well-being of the guardian, child's ordinary comfort, contentment, health, education, etc. Now, there are circumstances where neither the parent nor the neither of the parent is actually suitable to be appointed as a guardian. In certain circumstances or in such circumstances, courts have also sent the child to boarding schools. So I'll just give you the citations like Shioli Hati versus Somnath Das, 2019, Volume 7, SCC 490. The child was removed from the influence of home life and directed to continue to remain in the boarding school. It was held that in the facts and circumstances of the case, this was considered the best way to serve the welfare and interest of the child, as the atmosphere in her home was unhealthy, which had caused a very great strain on her nerves and had certainly affected her healthy growth. Similarly, in Amrik Rai versus Satpal, AIR 1983, Punjab and Haryana 304, the court directed that the child should be sent to a boarding school as the acrimonious atmosphere in the house would have a bad effect on the proper growth of the child. Then it is very important to remember that siblings should not be separated, especially when they are very close to each other. In case titled Shaleen Kabra versus Shivani Kabra, 2012, Volume 2, RCR Civil 974. The Honorable Apex Court has given this observation. So here the court had given custody of elder son to the husband and that of the younger son to the wife. So this order was modified and the custody of both the children was given to the father with visiting right to the mother at the expense of the father. Now, what happens if the father is in live-in relationship? In case titled Naresh Kumar versus Anita Rani, 2019, Volume 2, RCR Civil 366. It was held that the court cannot approve this kind of social setup because it would give a wrong signal to the society at large and would create an adverse impact on the tender mind of the child. And there are chances that the child would learn that live-in relationship is a way of life. Now, the principles in relation to the custody of a minor child are well settled. In determining the question as to who should be given custody of a minor child, The paramount consideration is the welfare of the child and not rights of the parents under a statute for the time being in force. But there are circumstances where the custody is not given to the parents, but is given to other relatives. In Jayaprakash Khadaria versus Shyam Sundar Agarwal, 2000, Volume 6, SCC 598, there was a dispute between paternal and maternal grandparents, and here the custody was given to paternal grandfather. Then in Anjali Kapoor versus Rajiv Bajal, AIR 2009, Supreme Court 2821, the custody of the child was handed over to the grandmother rather than the father. In Shyamrao Maruti Korvate versus Deepak Kisanrao Tekram, 2010, Volume 10, SCC 31, the custody of the minor child was given to the maternal grandfather and not to the father. In Neelam versus Mansingh, 2015, Volume 2, RCR Civil 291, custody of minor child residing with grandparents where father is dead and the mother is facing criminal prosecution under Section 306 IPC for abetting his suicide. In such circumstances, custody of the child was ordered to remain with grandparents, and the mother was even denied the visitation rights. Then in Kirti Kumar Maheshankar Joshi versus Pradeep Kumar Karuna Shankar Joshi, 1992, Volume 3, SCC 573, the Honorable Supreme Court handed over the custody of minor children to maternal uncle, refusing the preferential right of the custody, preferential right of the father to the custody of his minor children. Then in Neel Ratan Kundu versus Abhijit Kundu, which we just discussed here and before, a case under Section 498A IPC had been registered against father of the child. Here, the custody of the five-year-old child was given to the grandparents, and the custody petition of the father was dismissed. So again, a question arises whether it is permissible to hand over the custody of the child to an institution, ignoring parents' claim. So ordinarily, no. This was answered in Beata Agnieszka Sobieraj versus State of Himachal Pradesh, 2016, Volume 4, RCR Civil, page number 4. But there's another case, Shaurya Gautam versus State of UP, 2020, SCC Online, Allahabad, 1372, where it was observed that if a natural guardian is facing criminal charges relating to death of the spouse, then in that event, the court allowed custody of the children to remain with the ashram, and the visitation rights to the father were also declined. Then in case of custody of illegitimate child, the mother has an indefeasible legal right to natural guardianship vis-a-vis an illegitimate child. This is Dharmesh Vasant Rai Shah versus Renuka Prakash Tiwari, 2020, SCC Online, Bombay, 697. Now, preferences and inclinations of child are important in determining issue of parental custody. In case titled Samriti Madan Kansagra versus Peri Kansagra, 2020, SCC Online, SC 919, the Honorable Apex Court has observed that the court can consider the preference of the minor if she or he is old enough to form an intelligent preference. It would be in the best interest of the child to transfer custody to his father, as if the preferences were not given due regard, it could have an adverse psychological impact on the child. And this is very important, that the psychological aspect of the child's emotions should be considered. In Jitendra Arora and others versus Sukriti Arora and others, 2017, Volume 3, SCC 726. It was held that court should desist from passing order for custody contrary to the will of the girl child, which may give rise to tormenting and disturbing experience in her mind. In this case, the custody of the girl child aged 15 years was given to the father by holding that it was for her welfare. Now, in Purvi Mukesh Gada versus Mukesh Popatlal Gada and others, AIR 2017 Supreme Court 5407, it was held that regard should be given to the child's opinion if she can understand his or her welfare. The Honorable Apex Court, besides other factors, also took into consideration the wishes of the minors and accordingly awarded custody to the mother. It was in Ashanka versus Prakash 2020 SCC Online Bombay 3497. The Honorable Bench interacted with the child aged 10 years in the chambers, and she stated that she was comfortable at her father's place, but her attachment with the mother was also explicit, and she showed willingness to meet her mother. So the Honorable Bench stated that it is not basing its conclusion only by taking into consideration the better financial position of father, but that is one of the factors amongst others. Visiting rights were granted to the mother in view of the child's inclination to meet her mother frequently, and it was held that a father would bear the travel and stay expenses. So in Vijay K. Prasad versus Ranjana 1999 volume 9 SCC 544, the child stated that she wanted to stay with the father. As she was staying with the father since the past 8 years, the child was ordered to stay with the father, and the directions given by the mother that she would spend holidays, the directions given by the family court that the child would spend time on the time of holidays with mother was set aside. Now, what is important is that court has to see that preferences of the child are free from any undue influence. The tutored and pre-prepared statements of the minor are not to be considered as their wishes, and importance has to be given to their level of maturity and their surroundings, etc. The court has to be satisfied that the preference of the child is free from any kind of undue influence. Now, Section 26 of the Guardians and Wards Act says that a guardian appointed by court cannot, without the leave of the court by which he was appointed, remove the child from the limits of the jurisdiction except for such purposes as may be prescribed. Section 44 of the said Act prescribes the penalty where the ward is removed from the limits of the jurisdiction of the court by the guardian without the leave of the court. Now there is, we can talk about the international child abduction also. No, there's no statute or legislation regarding the rights of parents in case of international child abduction. India is not a signatory to any convention or treaty related to the international child abduction. The laws governing such a situation are only precedent based. In 2016, the Ministry of Women and Child Development had drafted a bill, the Civil Aspects of Child Abduction. In the 263rd report, the Law Commission submitted a draft bill, the Protection of Children, Inter-Country Removal and Retention Bill 2016, but still there is no legislation in this regard. In Nithya Anand Raghavan versus State and City of Delhi, 2017, Volume 8, SCC 454, it was observed that Indian courts are not to get fixated with orders of the foreign courts, and that they have to be guided only by the best interest of a child in custody battles. It was further held that courts in India were not obligated to ratify the orders passed by foreign courts when the paramount interest of the child could be in peril by such approvals, and noted that India was still not a signatory to the Hague Convention and would therefore not breach any international obligation if domestic courts applied their minds independently in custody cases. It further underlined that the principle of comity of courts cannot be given primacy or more weightage for deciding the matter of custody or for return of the child to the native state if the child has been brought within India. The courts in India may conduct summary inquiry or an elaborate inquiry on the question of custody. In the case of a summary inquiry, the court may deem it fit to order the return of the child to the country from where he or she was removed, unless such return is shown to be harmful to the child. In other words, even in the matter of a summary inquiry, it is open to the court to decline the relief of return of the child to the country from where he or she was removed, irrespective of a pre-existing order of return of the child by a foreign court. The invocation of first strike principle as a decisive factor would undermine and whittle down the wholesome principle of the duty of the court having jurisdiction to consider the best interests and welfare of the child, which is of paramount importance. With regard to non-convention countries, the law is that the court in the country to which the child is removed, while considering the question, must bear in mind the welfare of the child as of paramount importance and consider the order of the foreign court as only a factor to be taken into consideration. The summary jurisdiction to return the child be exercised in cases where the child had been removed from its native land and moved to another country where maybe his native language is not spoken, or the child gets divorced from the social customs and contacts to which he has been accustomed, or if its education in his native land is interrupted and the child is being subjected to foreign system of education. For these are all acts which could psychologically disturb the child. Now again, the summary jurisdiction be exercised only if the court to which the child has been removed is moved promptly and quickly. The overriding consideration must be interests and welfare of the child. Even in Ruchi Maju versus Sanjeev Maju, AIR 2011, SC 1952, it was observed that principle of comity of courts ensures that foreign judgments and orders are unconditionally conclusive of the matters in controversy, but in the matter of custody of child interest and welfare of the minor being paramount, a competent court in this country is entitled and indeed duty bound to examine the matter independently, taking the foreign judgment, if any, only as an input for its final adjudication. In Elizabeth Dinshaw versus Arvind M. Dinshaw and another, 1987, SCR, Volume 1, 175, the Honorable Apex Court has reiterated that a parent doing wrong by removing children out of the country, it should not gain any advantage by his or her wrongdoing, and it is the duty of the court to see that no such benefit is given to the wrong parent. Now, jurisdiction point has already been discussed by Mr. Anil Malhotra. That is section 9. Person, in case of a person, it shall be made to the district court having jurisdiction in the place where the minor ordinarily resides, and property where the minor ordinarily resides or where the property is situated. Now, the word minor ordinarily resides has also been discussed by Mr. Malhotra, but I would like to refer to a judgment on this point. This is Jagdish Chandra Gupta versus Dr. Kumari Vimla Gupta, AIR 2003, Allahabad 317. The ordinarily resides and residing at the time of the application are not synonyms and stipulate different situations which are not interchanged. The place where the minor ordinarily resides indicates a place where the minor is expected
expected to reside, but for special circumstances. It excludes places to which the minor may be removed at or about the time of the filing of the application for the enforcement of the guardianship and custody of the minor. The place has to be determined by finding out as to where the minor was ordinarily residing and where such residence would have continued but for the recent removal of the minor to a different place. The mere fact that a minor is found actually residing at a place at the time of the application is made by itself is not sufficient to determine the jurisdiction. Now, where minor ordinarily resides has been used intentionally in the statute for excluding places to which the minor may be removed at or about the time of filing of the application for the enforcement of the guardianship and custody of the minor. The legislature intended to avoid inconvenience to the minor. Jurisdiction is conferred upon the court where the minor has been residing for a reasonably long period. If the minor, less than 5 years old, has been wrongly removed, the custody of such minor shall be deemed to be with the mother. Now, in this regard, I'll refer to cases Shashidhar versus Rupa, ILR 1992 Karnataka 2791. In this case, the wife was driven out from the matrimonial home in Mumbai, but the custody of the child was not given to her. She started living in Mysore and filed the petition for custody of the child. The Honorable Karnataka High Court held that under the Guardians and Wards Act, a minor child is expected to be with the custody of the mother, and therefore the words ordinarily resides should be construed as the place where the mother resides before the presentation of the petition. In Kuldeep Kaur versus Sukhwinder Singh, 2009, Volume 9, RCR Civil 485. The claim was made by the father for the custody of minor daughters. Mother was residing in District Alwar. Daughters were admitted in a school there. Address of mother in the petition is also shown as that of District Alwar. So in this case, the Honorable Punjab and Haryana High Court has held that as per Section 9 Guardians and Wards Act, the court at District Alwar is the competent court. Now there's another case, Akshay Gupta versus Divya and others, 2021, Volume 1, RCR Civil, 722. In this case, after separation, mother was residing in Panipat. Physical custody of the child was with the mother. Child was 3 years and 7 months old at the time of filing petition. The child was admitted in a school in Panipat, but later she was wrongly removed by the father from the custody of mother and taken to Yamunanagar. I would repeat that the child was wrongly removed by the father from the custody of mother and taken to Yamunanagar. Of course, the facts are disputed, though it is claimed that the mother had abandoned the child, which is of course a matter of evidence. In this case, the jurisdiction has been held of Panipat, from where the child was wrongly removed. In Regan Jayakumar versus Shami Sahul, ILR 2015, Volume 3, Kerala 41. Here the parents are living separately at different places and the minor was not residing with them. The primary question is, which is the place where the minor ordinarily resides? The minor child was studying in a school at Pune. So it was held that the District Court Pune, where the minor ordinarily resides, will get the jurisdiction. Now, for ascertaining that jurisdiction, the family court can verify the school certificate, extract of admission register, and other relevant documents to decide the disputed question of fact for identifying the place where the minor ordinarily resides. The school record should be, of course, of a sufficient long period. Now, a question was raised whether this jurisdiction can be, the question of jurisdiction can be treated as a preliminary issue. Now, unless the jurisdictional facts are admitted, it can never be a pure question of law. When the facts are disputed, then the question about jurisdiction cannot be treated as a preliminary issue, as it is a mixed question of law and facts and requires inquiry into the factual aspects of the controversy. Now we'll talk about revocation, variation of orders. Section 26 of the Hindu Marriage Act. Courts can pass interim orders in any proceedings with respect to custody, maintenance and education of minor, and make such provisions in the decree as it may deem just and proper with respect to the custody, maintenance and education of minor children. The section also authorizes courts to revoke, suspend or vary such interim orders passed previously. In Vikram Veer Vohra versus Shalini Bhalla, AIR 2010 SC 1675, it was held that the custody orders are always considered interlocutory orders, and by the nature of such proceedings, custody orders cannot be made rigid and final. They are capable of being altered and molded, keeping in mind the needs of the child. Similarly, in Rosie Jacob versus Jacob A. Chakramakal, 1973 1 SCC 840, all orders relating to custody of minors were considered to be temporary orders. And with passage of time, the court is entitled to modify the order in the interest of the minor child. The court went to the extent of saying that even if orders are based on consent, those orders can also be varied if the welfare of the child so demands. Then Section 38 of Special Marriage Act. This is same as Section 26 HMA, and the petition is maintainable under this act if both the parents belong to a different religion or have undertaken a court marriage. Here also, the application can be disposed of within 60 days from the date of service of notice. The section also authorizes courts to revoke, suspend, or vary such interim orders passed previously. Then what happens?
Yes, Madhu.
Under Section 45(1), if the person in custody of the child disobeys the order passed under Section 12, subclause 1, he incurs the liability of payment of prescribed amount of fine as well as detention in civil prison. Unlike the scheme of code, CPC, dealing with the execution of decrees and orders of civil courts, Section 45(1) does not seem to limit the order of detention to any specific period. The detention continues till the child is produced or guardian in default undertakes to produce the child in compliance with the order of the court. In case of failure to fulfill the undertaking given by the concerned parent, within the stipulated time, he may be arrested and recommitted to the civil jail. This is Section 45, subclause 2. Now, this is the problem that is faced by most of us, that the child is not produced in the court or is not allowed to meet the non-custodian parent. So we can always resort to Section 45 of the Guardians and Wards Act. So as we are running short of time, I think I'll just end it. But of course, I'll point it out that the rules framed by the Honorable High Court under the Guardians and Wards Act 1890 are contained in Punjab and Haryana High Court Rules and Orders, Volume 2, Chapter 2B. So with that, I'll end this talk. Thank you so much.
Thank you, Madhu. I'm happy that this particular session, which was so vital, covered by both Mr. Anil Malhotra and Madhu Khanalali. You know, so much about determining the best interest of the child, and therefore so much has been shared and yet so much remains to be shared in this particular context. Thank you so much for taking this particular session in a wholesome manner. Both of you have done and contributed extensively in furtherance of this particular session. Thank you so much. Look forward to have you on some other occasion also. Mr. Malhotra, of course, Madhu is with us and we continue to have our association. Thank you, Mr. Malhotra.
So one last question. Where is lunch?
At your residence.
I'm waiting for you.
Look forward to having you. Thank you.
Bye-bye, sir.
Bye-bye.